Title 21 United States Code, the Controlled Substances Act, controls marijuana at the federal level. The enforcement of this act is the responsibility of the Department of Justice. U.S. Attorney Jeff Sessions is in charge of that department. Title 21 United States Code, Controlled Substance Act, Part B, Authority to Control Standards and Schedules. Section 11, Authority and Criteria for Classification of Substances. Rules and Regulations of Attorney General. The Attorney General shall apply the provisions of this subchapter to the controlled substances listed in the schedules established by Section 812 of this title. In other words, Jeff Sessions has the ability to control marijuana/cannabis.
I wanted to raise again with you the subject of marijuana. Alaska is one of those states that has moved forward not only with the medical marijuana, but also the sale and cultivation of recreational use, a very aggressive state regulation. This was not something that I had supported through that statewide initiative. In fact, I worked against it, but it was passed resoundingly through the state, and my constituents expect me to work to represent them. Mr. Chairman, I'd like unanimous consent to enter into the record a resolution that was recently passed by the Alaska Legislature.
Without objection.
This is HJ Res 21. It was passed unanimously out of both houses, and it urges the federal government to respect the authority of the state of Alaska to regulate marijuana use, production, and distribution, and generally respect states' rights. Mr. Attorney General, we have talked about this in the aftermath of your decision to withdraw the Cole Memorandum. I had been disappointed with that and expressed that I was concerned that the Department of Justice was less than a full partner with the states. I do understand that the White House has expressed support for legislation that will respect state supremacy when it comes to regulation in the spirit of federalism. I think that the comments that were made by my colleague from Hawaii in terms of members evolving on this is important, but I do think as we're seeing the states move forward, legislation like this is timely. The states are telling us, though, that they need the Department of Justice to be a partner in the orderly administration of states' regulatory regimes and not standing in the way as an obstacle. So I understand your position on this. Again, we've had many conversations, but I would hope that we could have your assurance that within the Department of Justice, that the department will not be an obstacle to the consideration of this sort of legislation that may move forward.
Well, I can't make a commitment about what position we would take at this time until we know exactly what's involved, but it's not so much on a question of supremacy as a question of simple law. Alaska can pass laws about drugs that make certain drugs illegal that Washington does not make illegal, and therefore can't be prosecuted in federal court, but could be in Alaska. Likewise, the federal government has passed some laws regarding marijuana that I'm not able to remove from the books. Congress, you have passed them. They're on the books.
Part B, Section 811A2. The Attorney General may, by rule, remove any drug or other substance from the schedule. Either the Attorney General misspoke or he is unaware of this part of the Controlled Substance Act.
I'm not able to remove from the book. I'm not able to remove from the book. I'm not able to remove from the book.